All right, joining me now is Mr. Mukul Rohatgi, Senior Advocate, Supreme Court, former Attorney General of India. Appreciate you taking the time out and joining us, Mr. Rohatgi. You've called the judgment today a balanced one. Why do you say that?
So, madam, let's first understand that a judgment on bail is not a final verdict on the accusation. That final verdict will render conviction or acquittal. So this is a judgment which only looks at a prima facie view of the nature of allegations, the nature of the defense, the nature of time taken, the nature of the material, and the complicity on a prima facie basis, and then take a call whether somebody should be on bail pending trial or not. That's the first thing. So please don't read the judgment as if it's a final Bible on the case. That is not so. Why I called it balanced was, after having the benefit of reading this judgment an hour ago, I find that 5 out of 7, I think, have already got bail.
Correct.
The 2 who haven't got bail, their role has been found to be more central and more complicit prima facie on the materials available as per instigating these riots in which 50 or more people lost their lives, that it was a deliberate scheming, etc., etc. Now, I have no reason to doubt what the court has said. The court has discussed the issue of delay, which has happened till today, and come to a conclusion that delay by itself will not automatically be a trump card for bail. But I have one issue with the judgment which I want to raise. All in all, you can say it is balanced, but one issue I want to raise, and that is this, that the court has not considered what is the prognosis for the future. Assume that 5 years have gone by and the trial has not started. That itself is a big blot on the judicial system and the prosecution, the benefit of which should go to the accused. That's the first thing, which I think there is some flaw in the judgment. But the judgment does not notice as to when will there be light at the end of the tunnel. I find that several charge sheets have been filed. Charges are yet to be framed or are being framed. The trial is yet to commence, and there are about 800 odd witnesses. So if the prognosis is that the trial is not likely to finish in the near future, that is also an entitlement to bail, and that the judgment has not considered. Lastly,
right. Make your point, sir.
Lastly, I would say that it leans in favor of reasonableness, because the last portion of the judgment gives another chance to these 2 persons, that if there is no proper progress, they can apply for bail afresh after 1 year. So it's not absolutely a dead end for them. There is one more chance after 1 year. I wish it was 6 months instead of 1 year, but that is still another chance. And I think that this trial is no way going to be any early completion, and
Exactly.
these chaps will therefore get bail in the next round after 1 year. They'll have to suffer 1 more year. Yes.
But Mr. Rohatgi, that's where the criticism comes in on why many are calling this judgment flawed, which is why, what will this 1 year bring, which 5 years of incarceration hasn't been investigated yet, and the sheer fact that 5 years, which you also yourself admitted, in jail, the trial is yet to begin, the charges haven't been framed yet, somewhere down the line erodes and undermines the presumption of innocence, which is the founding principle of criminal justice in this country.
Except that, you are right, except that 2 things. One, when you are dealing with cases of sedition and cases of unlawful activities which are crimes against the nation, against the fabric of the nation, the, the absolutely pure principle of bail and not jail will to some extent get diluted. On the other channel, I gave an example. Look at PMLA. The maximum sentence for money laundering is 7 years. But there, under the law, Parliament has put fetters on the court granting bail even in a 7-year sentence unless the court finds at least prima facie that the person is innocent.
But
I don't know how a court can
Mr.
find a...
Rohatgi, you give the example of the PMLA. Now, let me come back with the example of PMLA only, sir. You've had the top court of the country which granted bail where PMLA was concerned, and you can draw a parallel here with the UAPA under which these two boys have been charged under. And you had Arvind Kejriwal and Manish Sisodia who were granted bail. A precedence of sort was set by the Supreme Court, which today many cases are argued in court on the basis of that precedence. And
No,
here...
you're right. Every day I am arguing for individuals in favor of bail, but I would only say, I was giving that example to say that even in a 7-year sentence case, the maximum sentence, the legislature has put some fetters on the court granting bail. I am contrasting this with the case of UAPA and sedition under 124A, where the punishment can even be death. Therefore, the same yardstick may or may not apply. But as I said, I would have been happier if the court had said we give 6 more months to the prosecution to complete the trial, remove the number of 800 witnesses and bring it down to say 50 and finish with this case. 6 more
sir,
months could have
but
been...
the argument is, what will those 6 months or what the court, the learned bench has decided, a year, actually prove? What will one gain from that?
I will tell you. See, one lives on hope. Now, with a stricture like this, that you are getting 1 more year, if the prosecution pulls up its socks and examines all the relevant prime witnesses, if not 800, in every case, prime witnesses are 10 or 15 or 20. If they examine all 10, 15 and 20, they can certainly examine in 6 or months. Now, if those witnesses and their evidence points towards no complicity, then straight away after 6 months, based on that material, they will be entitled to bail. But
sir, it's been 5 years. If the investigation hasn't been completed yet, is again something which the defense had argued in court.
So, madam, as I said, it's not always an inflexible rule of delay in trial. Generally, this rule will work in favor of bail. But in this case, I also found that some amount of blame was put on the accused for the delay in the last couple of years. So kind of delay was apportioned between the accused and the prosecution. And it was not a case of innocent man sitting in jail and the delay just being occasioned by the prosecution. There are some passages to that effect also. So now look, 5 of them out of 7 have got bail. 2 remain. For them, there is another window. After 1 year, according to me, it should have been 6 months, if at all. And then, they have another chance to show that if no other material comes forward in the form of independent witnesses, then they will get it. I mean, you look at it in a very broad fashion.
But Mr. Rohatgi, let me ask you one final question, because we are speaking about 5 years of incarceration, we are speaking about no trial, we are speaking about no charges fixed, yet jail and denial of bail. Now, I'll take you back, sir, to August 13th, where the bench of Justice Okha and Justice George Massey of the Supreme Court said the legal principle, bail is rule, jail is exception, is applicable to offences under special statutes like even UAPA. And they gave somebody bail who was under the anti-terror, charged under the anti-terror law, stating that denial of bail is the denial and a violation of fundamental rights.
So, madam, I agree with you, but every statement of the law is not to be read in abstract. The law is applied to facts. Now, I don't know what the facts are of the case that you are talking about. That's an abstract statement that even in UAPA, this is the rule. But I mean, if you look at the facts, if they are correct, I don't know whether they're correct or not, but if you look at the facts, if people have instigated a riot in which 54 people have died, that can't be, you see, just applied on an
Okay.
abstract principle that bail must be granted in UAPA. You have to, the flesh and blood of a case is facts. It is to those facts that you apply a legal principle. There is no legal principle in vacuum. That's very important, madam.
Okay.
So reading one line from here or one line from
Fair
there,
point.
not going to help.
Okay, let me, because the PMLA, the UAPA is a draconian, archaic law, is something that is being debated far and wide, sir, which is in the court as well. Now, where the UAPA is concerned, and with what you speak of, will this now set a precedent in other cases? Like, and we'll draw parallels here, which you yourself drew of the PMLA. Because once you had an Arvind Kejriwal and Manish Sisodia who got bail from the Supreme Court under PMLA, it made it very simple for others as well, charged under PMLA to get bail because precedence was sought. Do you think this will now also set precedents where people who have been charged under UAPA will find it that much more difficult?
I don't think so that at all, madam. As far as bails are concerned, there is no great precedential value. As I told you, they are not final judgments. They are judgments on the facts of a case, whether to grant liberty or not. So there is no great presidential value of these bails. You have to apply general principles to the facts of every case. So it's not as if that everything tomorrow will become difficult or everything tomorrow will become easy because of Sisodia. I can give you any number of examples that even with Sisodia's law being there or judgments being there, people have been denied bail by the Supreme Court even after 1 year or 1.5 years. In case of PMLA, where 7 years is the maximum sentence. I have done cases where the allegation is that somebody has cheated banks of 5,000 crores or 10,000 crores.
Okay.
That also affects the mind of a judge. And they are not getting bail.
All right, sir. So net, Mr. Rohatgi, you say this was a balanced judgment, but two things where you say that it's been 5 years, it's a blot in the judiciary, that trial hasn't begun. That's one point that you make. And the second point that you make is that you wish that the 1 year window was brought down to at least a 6-month window.
Yes, yes.
Those are the 2 points?
That would have made it, passable. It would have made it...
more balanced.
Yes, absolutely. Absolutely.
All right, sir.
Thank you.
Thank you, Mr. Rohatgi, for joining us. Thank you.